Criminals right now can get out of going to jail if they can showcase that they have a mental illness for most crimes committed in California. This is an unintended consequence of a law passed recently. My guest today is Matt Greco, who's a deputy district attorney in San Diego. He's overseeing many court cases, and he's seeing what's happening in the courts today.
Average Californians would probably be surprised, first of all, at the scope of mental health diversion being applied, even if you've committed an attempted murder, if you've committed a robbery, if you've committed an assault, if you've stalked somebody.
So here's what I'm understanding. So somebody commits a crime and says, I have caffeine disorder, that's why I robbed the bank. Would they get out free and they get a program? Would they end up going to jail, or how does it work? I'm Siamak Korami, welcome to California Insider. Matthew, it's great to have you on. Welcome.
It's great to be here. I'm happy to join you.
There's a law that has affected the judicial system in California. People that commit a crime might be able to get out of it by saying they have mental illness. Can you tell us what this law is about?
Sure. It's called mental health diversion, and it came into being in 2018 to address the very real issue, the intersection between mental illness and criminality and criminal conduct. And the idea behind it was to attempt to reduce recidivism by addressing mental health. But with all good intentions, there was a twist in the way that this was implemented and created unintended consequences and unintended victims.
So if they have mental illness, they commit a crime, then they can have that dismissed because they have mental illness and get treatment, is that?
Yes, and there's are two eligibility factors. One is that you have a mental disorder that has been diagnosed by a mental health professional during the past 5 years, and it was diagnosed by not necessarily a psychologist or psychiatrist. They were very expansive, and they just said it could be a marriage and family counselor. It could be a social worker that diagnosed you. You could potentially qualify. The unintended consequences are both the people that are doing the diagnosing, but also the types of diagnoses that qualify include, for instance, a caffeine disorder. So if you don't get your coffee and you're going through withdrawals, then potentially you would qualify under one of these factors.
So how would average Californians look at this? How would they get impacted?
Average Californians would probably be surprised, first of all, at the scope of mental health diversion being applied, even if you've committed an attempted murder, if you've committed a robbery, if you've committed an assault, if you've stalked somebody. People would be surprised that the type of crime that potentially you could be eligible for a mental health diversion. I think that's one way. I think the second way is that the courts have really felt that they don't have discretion to say no. And so really, I think people would be surprised at how courts feel boxed in, how they feel like they don't have the ability to say no or to do what would make sort of common sense adjustments, and that they should be using their knowledge, their experience, their discretion to make the best possible decisions, not just to treat mental health illness, but also to protect the public.
Can you tell us about the mental health diversion? What does it mean for people that don't know about it? So does the court allow them to go get mental?
The purpose of mental health diversion is you're going to receive treatment that relates directly to the mental disorder that was related to your crime. Those things will be tightly connected. The reality is that they're not. But the idea is you go through a treatment process. You can be on this mental health diversion for 2 years. If you are successful, then at the end of that 2 years, the case is dismissed as if it never happened. So whether it's a vandalism or a robbery, whether it's an assault, whatever the crime is, it's as if it didn't happen. And the premise is that by treating the individual, it's likely that they will not recidivate. They won't commit a new crime.
So now, when was the time you saw that something is wrong with this? It's not working as it was.
In the beginning, judges were struggling to see the connection between mental illness and the crime. And an example, I mean, I was trying to use an example of, for instance, a caffeine disorder or a bereavement disorder. The most typical is a post-traumatic stress disorder. So, for instance, if someone had been sexually molested as a child, they potentially could suffer from post-traumatic stress disorder. But linking that to the crime that they've committed, a residential burglary, a robbery, a car burglary, is very tenuous. And so from that period of time, from 2018 to 2023, many judges really had difficulty with that linkage. And so mental health diversion wasn't limited, but there were
limited cases because they say this doesn't relate to them. What happened in 2023 that?
In 2023, there was a bill that changed that presumption so that simply having the mental illness, now it is presumed that you have, that the mental illness
caused you to commit the crime.
And the burden then shifts to the people, to the state, to prove that they didn't, that we have to prove a negative. We have to prove that your mental illness didn't require you to, or didn't impact you, wasn't related to you committing that crime. There have been some very recent cases, including a case that just came out on April the 4th of this year, where the criticism by the appellate court overturned a court's denial, defendant the right to have mental health diversion. And this individual reported being molested and assaulted at 14 and 17, and later was involved in a series of car burglaries with a couple of other individuals. And the court said, I don't see this connection. The appellate court said, no, the burden is on the people to prove that there wasn't a connection. And so that change is really dramatic. In effect, what's happened is it's like a baseball game where at the end of the game, it's 0-0, and what we're saying is, okay, so the home team wins. Well, that isn't the rule. I mean, it doesn't really make a whole lot of sense. That's what a presumption is. And the presumption here is, well, if you have the disease, it has to be connected, and the people have to prove it. But in effect, we're proving a negative, which when you think about it,
makes it a lot harder.
It's almost impossible to prove that negative.
Now, what percentage of people, criminals, have these like mental illness issues?
So it's hard to say. We have a tremendous a growth of
different kinds of disorders. You mentioned coffee. Is there any other examples that we might find?
Well, bereavement. So for instance, if you've lost a loved one or a close family member and you are suffering depression, PTSD, schizophrenia, and so forth, but we have a lot of bipolar. So if you're manic or depressive, all of that would be included. And so the general population that are law-abiding have a lot of these mental health disorders. And so part of what has happened is...
So the court will immediately take that. So if there's some mental illness that somebody has and then they committed a crime, they immediately will say these two are connected, right? You are doing that because you had a mental illness.
And in large part because of this presumption, because there is this presumption that these things are true. What that really does is it eliminates analysis so that you don't actually ask those hard questions. Were these two things related? Instead, the default is, of course they are, because there's a desire to treat over everything else. That the sense is, well, we'll just treat the issue and somehow that will solve the problem.
Some of you may be wondering, why are we talking about Shenyun on California Insider? It's a dance about China, but ancient China. I'm a big fan of Shenyun. I've been to it 14 times. Every year I go. The first time I went to Shenyun, it was so amazing. It was so uplifting. The colors, the energy, they put you into scenes of thousands of years ago. And you feel like how the ancient people lived. And you get to appreciate the history of humanity. There's a lot more to this show. It's gonna be here in Southern California, and I wanna make sure you guys go see it. You don't wanna miss this show. You have to see it at least once. And make sure to tell us what you think afterwards.
It was spectacular, so beautiful.
I thought I was going to heaven.
Oh, it was electric.
I'm getting chills talking about it.
It gets a 10 from me, that's for sure.
It was that good.
Absolutely marvelous.
Hands down the best show I've ever seen.
So here's what I'm understanding. So somebody commits a crime and says, I have caffeine disorder, that's why I robbed the bank. Would they get out free and they get a program? Would they end up going to jail, or how does it work?
The short answer is, if they show that they're both eligible and suitable, they would get a program and potentially the case would be dismissed. So that is a real possibility, because a bank robbery would not be one of the excluded crimes. So
it's not high enough.
It's not high
list
enough.
Of crimes.
And
Okay.
in San Diego, one individual that has assaulted his significant other 14 times was put onto mental health diversion, and yet violated all of the court's orders and did another assault. So the problem is that judges, they get the message. They're being told, hey, use these presumptions. The law is written in a particular way. They've read a series of decisions that have come out in the last year, all which suggest that they really don't have much discretion. In fact, the message over and over again is that they don't have any discretion, which is counterintuitive, because that's why we have them as judges, both public defenders and DAs. We want them to bring their experience from the criminal justice system, from working with defendants and working and prosecuting defendants, to the bench, to bring that experience and to ask the hard questions and assess risk. How risky is a defendant? And so
because the person can go out and commit another crime, right?
Correct.
And so essentially, in the case that I just brought up, like, let's say I had caffeine disorder when I robbed the bank, and the judge kind of looks at it and says, this is not a cause for you to be robbing the bank, but the judge cannot do much about it, right? They have to go.
The judge might feel that way. And in fact, this case that just came out last Friday, 3 days ago from when we're taping right now, dealt specifically with this issue, where the judge said, I see no connection between these things, and the appellate court said, that isn't enough. The people have been silent on this issue. They have to prove to you, provide evidence that there wasn't a connection. What does that look like? Does that look like an expert that comes in and talks to the defendant? I don't know what that looks like, but the idea that PTSD and an assault and sexual trauma that occurred years before somehow relates to going in and stealing and breaking into people's vehicles, that is incredibly tenuous. So one of the things you could do is simply take this presumption away, or try and find a way to give the court to restore their discretion that the appellate courts are actually taking away from them.
So Matthew, for those of us that don't know much about the legal system, can you give us some examples of what you have seen and how this law works?
Sure. Let me start by just saying that this isn't just a San Diego problem, it's across the state. There's another example of someone that received mental health diversion. A woman was getting her car worked on at a auto body shop. And the person that would later become a defendant showed up, started talking to her, and got her phone number, wanted to invite her out on a date, and she was friendly with him at the auto body shop and then thought differently about it and rebuffed him, at which point he began to stalk her and threaten to kill her and rape her and do a whole series of things to this otherwise stranger. And he wanted to, he had met her just before Valentine's Day. The court granted mental health diversion on that particular case.
What was his mental illness? Did he say he has a mental illness?
He did. He had a mental illness of post-traumatic stress disorder. So the court had to presume that the mental health disorder was somehow related to the stalking, which is very difficult
to disprove that. And it's on the court, on you guys, on the district attorneys to disprove that this is not connected.
Correct.
So then as a result of it, this criminal, somebody that's committed a crime, he will go home.
He will go home. And
he might stalk again the victim.
He doesn't. The victim, the message to the victim is that what happened to them doesn't matter. And in stalking in particular, that's a crime that's very personal. And because of all of these presumptions that the legislature has put into the system and really removed the discretion, courts don't feel like they can actually examine and sort of peel away the onion and look at it and say, does this make sense?
Do they connect with each other, the mental illness and the crime? So they're just going and saying, he has mental illness, he committed a crime, then therefore it's okay, right? Therefore they should get diversion.
They should, and if they meet these other conditions, and that includes, will the person come in and say, I'll waive time. So yes, I'll waive time for my jury if I get this. Will I comply? Yes, I want mental health diversion. Is there an unreasonable risk of danger to the community? Well, if you ask the victim of the stalking, she'll say yes, but that isn't what the legal standard is. The legal standard is, will this person commit a super strike, meaning rape, murder, use of a weapon of mass destruction? It's that level of crime that allows somebody to do it.
So Matthew, from what you're saying, essentially a big number of criminals, whoever that has a potential mental health background, which it's a big category, right? It's
Correct.
Like,
yes.
So essentially, anybody that has had those kind of diagnoses in the last 5 years, committing a crime, could get a pass.
And potentially diagnosed not by a psychologist, not by a psychiatrist, but by a therapist, a social worker, potentially because the definition of mental health professional is very, very broad. It isn't limited to a psychiatrist. So potentially it could be a social worker could diagnose you with having had that type of addiction. Most of the time it would be a bipolar, meaning you're both manic, which is, or depressed, and you're sort of high or low, or substance abuse disorder. So all substance, if you're addicted to methamphetamine, potentially you would qualify for a mental health diversion. And I think there's a very broad category of substance abuse disorders, or what we call dual diagnosis, which is both a substance disorder as well as a mental health disorder. And the substance abuse disorder is a mental health disorder, but they're slightly, they're both contained within the DSM.
So from what you're saying, a lot of cases could go through this.
Yes.
As long as they're not murder, rape, and weapon of mass destructions,
A
lot of cases could be...
Attempted murders, stalking, assault on your spouse, assault on a police officer. If you're shooting a gun from a vehicle, all of those things, potentially you are eligible, or you wouldn't be excluded. In fact, throughout the state, there are people that have received mental health diversion for almost all of those offenses.
So essentially criminals, and I'm not encouraging this, but criminals could go to a psychiatrist and get diagnosed and then go start committing crime and get out of it.
Well, I can't say that we've seen that. Is that a possibility? I hope not. I really hope not. And I don't think we should diminish the reality that there is a mental health crisis, and the intersection between criminal conduct and mental health disorders is real. The problem is in the details. And so there
is the fact that you have to prove that the mental disorder is connected to the crime. If that was in the discretion of the judges, it will solve this problem.
That is a big piece of the puzzle. Giving discretion back to the court is a huge piece of the puzzle. And one of the places to do it, if the court had the ability to actually require a defendant to prove that they were suitable, that they had a treatment plan that would actually treat mental disorder, and that it was appropriate for this defendant, that would increase public safety. That would address the mental health aspect of it. But courts right now are not required to do that. But that is one area, if they could ask those questions about the treatment program and how the treatment relates to the mental illness, that would go a long way.
Now, what about the public defenders? What are their thoughts on this?
The public defenders are not being bad actors by bringing mental health diversion.
They have to do it, right? That's what
they
part
have
of
to
their...
do it, and they've been incentivized to do it. They've been incentivized to throw it to the court, even if they question whether or not there's a link between the mental illness and the crime, or even if they think that the treatment plan might not address what the mental disorder is, or they don't have a treatment plan, which was one of the cases that we had in San Diego, where the public defender came in and said, we don't have a treatment plan, and the court nonetheless said it's an abuse of discretion not to grant mental health diversion.
So they still got the...
They still got it. So they're not being bad actors. They are acting within the system. They're doing what the system is pushing them to do, which...
Because otherwise they wouldn't be doing a good job as a public defender,
they
right?
wouldn't be. Their role is to focus on their client. We leave it to the legislature to consider holistically this process. And that's what's so disappointing about the way that mental health diversion came to be.
And Matthew, do you see the numbers increasing in the mental health diversion out of your what you guys are seeing?
It is very dramatic. The numbers are increasing on a regular and consistent basis. To give you an idea, we have around the county a minimum of 6 courtrooms that are dealing with this issue on a
in
weekly
San Diego,
basis.
Right? Yeah.
Yes, six courtrooms around the county that are dealing with it on a regular basis. It is very consistent at all levels of crimes, arson, assault, everything. And it is taking a lot of the time of our deputies, and that's not necessarily a bad thing. We're prepared to explore the mental health disorders of the individuals that have been charged with crime. What is disappointing is that in this very significant issue, I'll date myself, show me the beef. There was a commercial way back when with Wendy's that said, show me the beef. That's what the treatment plan is. It's the beef. It's the middle, it's the hamburger for the hamburger helper. We don't have that. So we have these presumptions, and then at the end of the day, the defendant doesn't ever really have to show a treatment plan in order to be found suitable. It's just, there will be a plan someday. And the public deserves more. All parties really deserve better. The defendants...
And even the person who committed the crime...
They deserve better.
Yeah, they need to have some sort of accountability to help them to actually take, if they're supposed to take the treatment, to take the treatment.
To take the treatment, and treatment that will work. That's what... And this is a hard issue, and so the sense is that they're skirting around that particular challenge. And that's unfortunate. But there is a solution that's on the horizon right now. There is a victims' rights group that is sponsoring a bill right now where they're trying to restore the discretion to the court and consider the treatment plan and require that there be a treatment plan, which seems to be a really common sense. And that's what this Senate Bill 483 does from Senator Stern, who is, I believe, from Los Angeles. And so we need to shift, and we need to open up the discussion, especially in the courtroom, so that we examine it. And to the people, to the individuals that say, oh, it's too hard, we're able to do a lot of things that are very difficult. And what the benefit to the person with the mental disorder is having the case dismissed. It is worth the effort to put a treatment plan together, to have it for the court, to give it to the court, and to explain this is how this individual will be treated so that this mental illness won't recur again, or if it does, the potential harm will be mitigated. It just makes sense.
So Matthew, you really care about this issue, and you care about the criminal justice system from what it looks like.
I do. I didn't necessarily think that this is where I was going to end up 30 years ago when I was graduating from law school. I worked for a civil law firm all the way through law school. They were paying for my bar, and they were involved in defending large trusts. And after being with them for 2 years, I started to have doubts whether I wanted to be an attorney. So I took a break from them and volunteered at the San Diego District Attorney's Office. I was sent to juvenile hall for a prosecutor. A new prosecutor, sometimes that's not exactly what they want to do because you don't actually have jury trials there. You have court trials with a judge. At the time, they gave all of the misdemeanors to the brand new interns. And so within a week, they had put a trial on my table and said, you're trying this case, and it was a 14-year-old girl that had stolen some clothes from Robinson's May. And back in 1995, we had VHS tapes, and so a loss prevention officer and a VHS tape walked in the door, and I prosecuted this case, got to put on evidence, put on a witness, and at the end of it, I was like, they pay people to do this? And I called the firm, and I told them I wasn't coming back, and I ended up just falling in love with it. I loved prosecuting. I knew I wanted to come back to San Diego, and I ended up coming back in 1997, and I've been here since. And I always said I would do the job for free up until I got married, and you have a house and a car payments and kids and everything else, but it has been fantastic. It's a great job because we do the right thing. We're trying to do the right thing for the community. It's a really good feeling. After 30 years, I still really enjoy it. It's an honor. It's an honor to get to stand up and say for the people. And it's an honor to say for the County of San Diego. And I encourage people to strongly consider law enforcement and strongly consider going into public service because you sleep really well at night.
Because you do the right thing for the community.
Because you do the right thing. And we have that saying and those are the instructions that I was given as an attorney and that I give to the attorneys that I work with, which is do the right thing. What do you think is the right thing to do here? And that's our North Star. And that's a really good feeling for anyone, and especially when you're doing your job, that's what you want to do. So it has been a fantastic ride, and the trial work has been great because you're basically just telling a story. You're telling a story within certain rules to a jury.
And is it challenging to get it right? Is it hard to get it right?
I will say this, that within criminal law, it has, I thought I knew a lot about it, and that was 20 years ago. And I recognize now how much I still have to learn. It is difficult, but you always come back to that question of what's the right thing to do. And so I learned that very early in my career in San Diego, where I had a case where I was in a trial, and it was a neighbor-on-neighbor dispute, and it turned out we developed evidence that the victim in the case was lying. And I went up to my supervisor and I laid it out, and the supervisor was unequivocal about it, which was, you know what the right thing to do is here. And I went down and I dismissed the case, and then I talked to the jurors afterwards, and it was a misdemeanor. So it was very early in my career, and I was kind of scared. Can I do this? And it was the right thing to do. I was supported by the people that supervised me, and so that has been my experience, which is great, but it can be very difficult to do.
So you're mentioning public service and being in the district attorney's office. What about the public defender's side? Do you think it's the same, what the level of service you guys are doing?
I'm always reluctant to speak for them. What I can say is I have a lot of respect for public defenders. They have a different role. Their role is to represent their client to the best of their ability. And a lot of them really, really care and love their job. But they're also, I mean, we speak privately, and you know, they have families, they have homes, they want to live in a safe community as well. So we just have different roles. So I wouldn't disparage them.
So essentially, it's the same role. In a sense, you guys are doing public service
They're
for the
doing
legal
a different,
system.
yes,
They're
a different
playing
public
different
service.
role, but it's the same, essentially.
Yes.
Where does the reward comes from for you guys? Because, you know, as a lawyer getting into public service, and the pay is probably half or less than half of the private jobs, right? And how do you guys get motivated?
Doing trials is very, very rewarding. You get an immediate result. You get an opportunity to impact a victim and help them not necessarily become whole again, but to find some justice, even if it's imperfect justice. And you realize you're playing a small role in keeping the community not just safe, but reassured that there's a sense of we'll obtain justice. So the rewards come oftentimes in very small ways, from talking to jurors afterwards, where they'll say things like, I was very reluctant to come in, I was hoping I didn't get picked, and this is a better experience than what I had thought. From victims and the families of victims. And in fact, on the very first murder that I ever had, it was a mixed race marriage. He was a polygamist. He killed his wife, and the trial went on for weeks and weeks, and the father was from Chicago, came out, and I couldn't really understand why I was having a difficulty making a connection with him. I couldn't make a connection, and I always thought I can talk to anybody, and I really cared about his daughter. Well, we went through the process. At the end of it, this gentleman came up to me, the dad, and he's African American, and his daughter was African American, and the defendant was a white man, a Caucasian. And the dad said to me, and this is decades ago, he said, he looked at me after the verdict of guilty, and he said, I didn't think my daughter would ever get justice here. And I didn't understand what he meant. I didn't get it. I was totally oblivious. I was colorblind in perhaps both good and very bad ways. I was totally naive. And he said, I looked and I saw a white prosecutor who picked 12 white jurors with a white judge, a white defense attorney, and I thought the fix was in. And now I'm going to go back to Chicago, and I'm going to tell my family and my friends that you can get justice in San Diego. And it doesn't matter what color you are. And that just floored me in terms of that there was that underlying issue, and that forever opened my eyes in a way that I hadn't been before. So it's those little things, those interactions with your victims and their family members, and you realize that you're involved in their life at their worst possible moment. and you're seeing people when they're suffering from the most grief they could possibly have. And you're trying to find a small way to bring them some justice. And it is really compelling. It will take over your life in terms of trying to bring that justice to people. And it really takes the place. You don't need money for that. That's a feeling that you always want to have, that you want more of, and that you can't really explain to other people. It's just something that you have, and it makes you passionate about what you do. So that's one of the benefits of this line of work.
Matthew Greco, San Diego Deputy District Attorney, it was great to have you on California Insider.
Thank you very much for having me, CMAC. I really enjoyed it. Thank you.
Let us know what you think of what's happening in the courts right now. Should we modify this law? You can always email me at siamak@californiainsider.com or comment. Remember, we read all of your emails and comments. We'll see you next time. And this is Siamak Korami with California Insider.